Earlier today, Judge Napolitano on this network said, you know, the media talks about this as being classified, but it also does cover top secret and secret. And it's pretty clear that at least 2 of Hillary Clinton's emails met that classification.
Right. The classification point that was on the tape that you played is really, in my view, a red herring. It doesn't matter whether it's top secret or whether it's even downgraded a level to secret. It all falls under confidential, and that's the classification under this contract. So that's a red herring. That's a violation regardless. Hillary Clinton agreed to 2 critical duties in this contract. She agreed to confirm and to protect. An affirmative duty to confirm whether this was confidential, protected information that was sensitive, and a duty to protect it from cyber attacks. On the first front, she's already said that she didn't really know about it, and unfortunately she had an affirmative duty. Now we know that, and she didn't do that. And secondly, in terms of cybersecurity, I think it was clearly at a minimum quite vulnerable. So you've got a contract, the contract is clear, and the consequences are significant. That's
just it, Kirsten. We knew we had this NDA, non-disclosure agreement. Many would say this is a smoking gun, or certainly a part of a smoking gun.
It may be, but I don't think it's really a game changer in this whole process, because a lot of people were operating under the assumption that this document did exist and she did sign it, because many top officials do. So the fact that now it exists, that's great. It's always good to have things in writing and on paper, but we already kind of thought it was there. You know, what the concerning thing is, and I think most Republicans say that they already know this, is the fact that it shows that Hillary Clinton either felt that she didn't need to go to upper management, she didn't need to go anyone else to decide what was classified. She could figure that out on her own. And secondly, that she probably didn't exercise the best judgment or discretion when, you know, disseminating emails with that kind of information. So it's bad news for her trust factor, but Republicans already don't trust her.
Well, it's already hit. Democrats are having a hard time trusting her too. But here's the thing, Seth, whether you claim ignorance or arrogance, are either one an excuse to break the law?
No, because it's all negligence, and the applicable controlling standard under the contract is whether or not you meet your standard of care or whether you're negligent. And it all comes down into the same siphon. If it goes down into negligence, then she has clear criminal exposure here. So it goes to intent. It's a clear contract. Look, there are 2 kinds of contracts, generally speaking, ones that are ambiguous and fuzzy and those that are clear. I've read the contract. It's pretty clear. So this was an obligation. It shows intent, and I really do think that it really is a very significant development.
Right. All right.
But at the end of the day, the FBI is conducting this investigation, but the DOJ has to decide to prosecute, and I don't think that's ever going to happen. So,
well, maybe she'll be prosecuted in the court of public opinion.
It brings it closer.
All right. It does. It absolutely does. Thank you both very, very much.